All rise. Oui, vous l'avez. Please be seated. Veuillez-vous asseoir.
Yes, Mr. Nichols, what I had in mind, unless you're going to suggest a method of doing this, is that what you were standing for?
No, absolutely not. No, I just, one point from the last session, Mr. Lauchi discussed the video, the surrender video,
Oh,
and
yes,
the error in the transcript. And I just wanted to state that I thought that we had submitted a corrected version already that's in the record. I think it's the same error we were talking about. And I can either send this in or read out the corrected version, ERNs.
When was it corrected? I mean, I was going to raise that.
Well, we disclosed the corrected, and I'll be guided by Ms. Sabatini if I mess anything up, but 29 March 22 is when we disclosed the corrected versions.
Well, this is really it was a criticism apparently of the legal representative of the victims who referred to that portion. I marked it actually, wasn't it? Of the video. That was Mr. Lauch's criticism. Just a moment.
Yeah, my only point was that
Anyway,
there was an error
Yeah.
that cast the accused in a worse light based on that error, and we fixed it and resubmitted it. So that's the point.
All
And
right.
I can email in these ERNs if anybody needs them or read them out.
Yeah. I think, Mr. Lauch, it was you that said that there was obviously
Yes, and the office of the prosecutor was more efficient than us in finding the corrected version. We missed it, if there is one. But, I mean, if it is fixed, we will just double check it.
Yeah, not to waste time, we'll send
right.
this on email.
Yeah, all right. It
Thank
seems
you.
to me sensible. Thank you very much, Mr. Nichols. Yes, we're simply going to go through. We appreciate that Council have already answered some questions, in fact, most, I think, and it may well be that we decide that, and we'll say so, that some of the questions have, if not directly being referred to, have actually been answered by Council. I think question 1 was answered. Question 2, yes, in fact, Mr. Lauch has dealt with that, yeah, so that's fine. Question 3 has been answered. Question 4, yes, Facebook, right. And that I don't think has been dealt with. And indeed, Mr. Edwards, I think, referred to some PowerPoint presentation.
Yes, but that I think the Facebook is a question for Malone Friends.
Oh, it is for the
I'm
prosecution.
not planning on saying anything about Facebook unless Your Honours
Oh, no,
really want me to. I doubt you do. No, the PowerPoint that we prepared is relating to your approach to asylum.
Oh,
reports.
the asylum
That's
application.
quite a bit further down the list.
Yes, so I don't think that has been answered, Mr. Nichols. And effectively, we wanted to know, I think, the defence arguments which ran between paragraphs 203 and 218 of their final written brief. Yes, and in particular that no attempt had been made by the OTP to authenticate any of the Facebook entries, as it suggested happened in Yekatom and Gaisoni, except that I think what happened in Yekatom and Gaisoni was actually a bit more complicated than it would appear. But is there anything really that you want to add to what you said about Facebook in your final brief?
Thank you, Your Honor. Very briefly, Ms. Whitford will respond to that.
It was
as
Miss
it was
Whitford's,
her
yeah.
witness.
Yes, it was. Yeah, Miss Whitford.
Yes, thank you, Your Honour, and I will just respond on that precise point that was raised in relation to the authentication, or really I think attribution is the right word to use here, because in terms of authentication, meaning are these genuine downloads from Facebook, that's not actually in dispute. So the issue here is about the attribution of the accounts to the sons. Now, the specific issue raised was firstly whether we had sought information directly from Facebook on that. In fact, we did, but we didn't receive any information from Facebook. We still haven't received anything. But what we say on that is that this is not a case where it's necessary. It might have been helpful to have additional information, but our position is that there is sufficient information before Your Honours to make findings on attribution. And that is based on the evidence of D37 in relation to the indicators that he testified about in the accounts themselves, in combination with the Facebook material that has gone into evidence, and then of course that would have to be seen in the context of all the other evidence in this case. And in particular, I would point to the witness evidence, especially from defence witnesses on the identities and so forth of the accused sons. So our position is that all of that taken together is sufficient for Your Honours to draw conclusions on attribution. And we say that that is actually consistent with Yekatom and Ngaisona. In that case, it will also be for the trial chamber to make findings on attribution, taking the Facebook material in combination with evidence in that case, so putting that material in its context. And for that proposition, Your Honour, I would refer you to the decision in the Yekatom and Ngaisona case, submitting that material into evidence via the bar table. And I'll just find the reference, Your Honour.
I think, well, isn't it the one in paragraph, footnote 643 to the defence brief?
The defence indeed
Yeah.
reference it, Your Honour, and at paragraph 12,
Yeah.
the chamber makes the point.
Yeah.
So those are the points that I would make on the Facebook evidence, Your Honour.
Yeah, all right. Right. I think we all remember the way the argument went at the time.
Yes.
In fact, I refound it. As far as question 5 is concerned, that has been dealt with by oh, well, maybe it has it or hasn't it? I've ticked it, but I'm not sure.
I believe I dealt with that one. Your
Oh, you
Honor.
did. Oh, so you did. Yeah, that's right. Okay. Question 6. Yes, definitely. Both sides have dealt with that. Question 7. Oh, yes. This was when what is called P869, but he never actually. He was your. A member of your team, and the question was when he'd become a member,
Yes.
because you asserted that. And in the filing, applying for more time, there was the letter attached.
Quite.
I'm not sure what the status is of that document then.
I can put on record what the date is, but
Yeah, but you can't give evidence. Do you see what I mean? Unless the do the prosecution accept that I think we can do it by an agreed fact, I mean, or whatever the equivalent is, that the man referred to originally as 869, but who then became part of the defence team and was the intermediary, was officially became part of the defence team according to the letter on the 1st of September 2022.
Well, Your Honors, I don't really have more information. I don't doubt my friend's letter at all, that is when the sort of official membership began on the team, and I think began to be paid by the registry, I suppose. I just don't know whether he worked with the team before that on a sort of intern basis or something like that. But I don't doubt that the letter given is fully accurate, and I don't contest that.
Yeah, well, the only reason that I raised it is because it was asserted as a footnote, but there wasn't any evidence to that effect in the case.
Yes.
But I mean, as I say, I'm not sure it matters that much.
Just to save time, I will stipulate.
That'll do.
It's very helpful, thank you.
Yeah. All right. Thank you very much. Right. That deals with that. Judge, question 8's been answered. Question 9 was addressed by the defence in writing. Question 10. Yes and no, I suppose. I mean, you've now got his civil and criminal records for what it's worth. By the way, I noted that he said that he was born, according to the records, Mr. Abd Al Rahman this morning said he was born a year later than the record seemed, or earlier.
No, you are referring, Your Honor, to the first version, the first translation that we provided to the chamber, which was erroneous and which has been corrected.
Oh, I
see.
see.
Actually, the right year is 1949.
Right. Okay. Yeah. Oh, because I did my hours when I was slightly at that one. Yeah. I've ticked it, but I don't know why. Did you reply to it, Mr. Nichols? That's the one about the failure to provide. Yes, I think you did, because I've ticked it.
Yeah,
I think it was a general.
If we're still on 10, during my opening, I
you did.
explained that I did not think that caused any prejudice.
Yeah. You did deal with that. Yeah. Question 12, yes. Question 13, I think that's Judge Alexis Windsor to ask that one.
Yes, but you missed 11.
Oh, you what?
Did you miss 11?
No, I've got it ticked as answered.
11?
Yeah. No, that's what Mr. Nichols. That's
13, I'm not sure. It was answered, sort of. But if any more precision can be given, it would be appreciated.
Certainly, Your Honour, this is in relation to question 13, just to be sure. Yes. Yes, I think you're right, Your Honour. I did, in the course of my submissions regarding the Delage Common Plan, touch on this, but I can be more specific with regards to the paragraphs that are mentioned in this question. So the short answer to the question is yes, we do say that Mr. Abd Al Rahman is to be held responsible for certain actions of the Janjaweed in connection with the charged incidents. How he is to be held responsible depends on the specific facts and the specific mode. In relation to these paragraphs, firstly 532 to 534 of our final brief, those paragraphs relate to the search and arrest operation in Delage. Now, those paragraphs don't describe any crime per se, they're more contextual facts, but there are crimes described during the course of the search in paragraphs 535 to 536 and 538. And our case is that as a co-perpetrator, Mr. Abd Al Rahman is responsible for all the crimes committed in the framework of the Common Plan, to which he made an essential contribution through his participation in the Common Plan, where Abd Al Rahman either meant for that type of crime to occur or was aware that that type of crime would occur in the ordinary course of events in the implementation of the Common Plan. And we say that that includes those crimes committed in the course of the search, and it would also include the crimes committed in relation to the killing of the group of detainees that included the community leaders on the third day of the incident on the Sunday, and that is partly described at paragraph 601 of our brief, and that's the paragraph mentioned in Your Honour's question, and our position is the same, that his responsibility for those is covered by co-perpetration.
Thank you.
Thank you, Your Honour.
Thank you. Question 14, yes, has been answered directly. Question 15, and again, I defer to Judge Alexis Windsor, my colleague.
Yes, this is a question for the prosecution. It has to do with crimes being committed during alleged attacks that are not the subject of the confirmed charges. So there are particular paragraphs cited here, but they're examples. So it's really a general question on this topic of uncharged events.
Thank you, Your Honour. I'll respond to that briefly. So this question relates to, as you say, attacks on non-charged locations. The paragraphs that you referenced related to crimes against humanity and also attacks in relation to immediately prior to the Kaddoum and Bendizi incident.
Right, but it is the kind of question that can be asked about other paragraphs as well. So a general question with respect to what is the prosecution's position with respect to uncharged events?
Yes, so our position with respect to those events, and I'll relate it first to the Kaddoum and Bendizi attack, to the crimes against humanities attacks, and then make some more general comments. So for those attacks on Kaddoum and Bendizi, we mentioned during our closing submissions on Wednesday, and obviously we mentioned in our brief that there were various locations that are attacked immediately before Kaddoum and Bendizi are attacked. We've included those attacks because we believe they are relevant to the pattern and modus operandi of the attack that you then see play out in Kaddoum and Bendizi, and to the accused criminal conduct and intent. We mentioned in footnote 1336 of our final brief that the relevance of considering evidence of prior events was considered by the Ongwen Appeals Chamber, and paragraphs 301 to 305, 946 to 948 are the relevant paragraphs. And in particular, in those paragraphs, the Ongwen Appeals Chamber found that evidence outside of the scope of the charges may assist a chamber in establishing the background and the context of the events that fall within the time frame of the charges, and in particular in relation to the Kaddoum and Bendizi charges and the charges of rape and other inhumane acts. I'll note in particular that the Ongwen Appeals Chamber specifically upheld the Child Chamber's decision to consider evidence regarding a pattern of victimization of women and girls, which was outside the immediate scope of the charges, to the extent that that evidence was relevant to its findings regarding the section gender-based violence crimes within the charges. And that's paragraph 948. More generally, in relation to crimes against humanity, we take the position, as we set out in paragraph 121 of our final brief, that the charged incidents, Kaddoum, Bendizi, Mukjar, Delej, they alone are sufficient to establish the widespread nature of the attack pursuant to Article 7.1 of the Rome Statute, on the basis that they are geographically widespread, they're spread over 2 localities, and temporally widespread. Those attacks are spread out over a period of 8 months. But nevertheless, We also include additional locations, which we list in paragraph 122 of our brief. And again, we do so because we believe that that provides Your Honours with additional context for the charged incidents. And that context is provided by, for example, I've mentioned the attacks for Kaduma Bendizi, similarly the attacks in Mukjar, the attacks in Delej. They followed the broader attacks on areas of Sindhu where persons were displaced. They were displaced to Mukjar, they were displaced to Delej, and some of those attacks that those additional non-charged attacks are attacks that were conducted in the course of that Sindhu operation, for example.
All right, so then do we understand that every time the prosecution seems to be relying upon uncharged attacks, it has to do with background and context? We should take it in that light.
Yes, that's right, Your Honours. And but also to the extent that there is evidence of the accused conduct in the course of those attacks, there may be inferences that you can draw in relation to the accused intent.
All right.
That's what I was about to ask. Is your position that this is a course of conduct? That the whole, from the moment they set off to when they finish up in Mukjar, this is a course of conduct?
Yes. Yes,
Yeah.
Madam President.
I see. All right.
Thank you.
Yes, thank you. Where does that bring us? Question 16. Yeah. There's been, we've already I think somebody's spoken about this already, but you say, the prosecution says, again, it's for the prosecution, this, that the Zakat office in Bendizi was looted by the Janjaweed. And the defence argue that this specific incident is not mentioned in the decision confirming the charges, and therefore we should give it no consideration. So what's your position in response to that?
That's me again, Madam President.
Yeah.
So in relation to this question, we refer to the looting of this Zakat office warehouse in our final brief. We recognise that the looting of that location is not expressly referred to in the operative part of the decision on the confirmation of charges. Nevertheless, the pillaging of that office, that warehouse, is mentioned in the confirmation decision at paragraph 91. So it is within the decision. And it's our submission, Your Honours, that on that basis, the operative part of the decision on the confirmation of charges isn't exhaustive of all looting events that occurred in Kadum and Bendizi. And in relation to that, I would note jurisprudence from the Ongwen appeals judgment that clarified that while the decision on the DCC may list specific criminal acts, the scope of the case is not necessarily limited to them. Sorry, that's the Entaganda appeals judgment. So it's the prosecution's submission that it's not necessary for the confirmed charges to make reference to every single item or building that was looted, as long as the evidence elicited at trial relates to the same facts and circumstances that are confirmed.
Well, there's been, as I'm sure you're aware, there's been a lot of discussion about separating out the operative part of a pre-trial chamber's decision on confirming the charges from that which is background. But you're saying, that Taganda says that we can take it into account.
Yes, exactly, Madam President.
Right.
And also, relatedly, on the issue of notice, this is something we pleaded in our pre-confirmation brief, and that we pleaded in our pre-trial brief, and we've included in our final brief. So we've pleaded it throughout, and it was included, as I say, in the decision on the DCC, although not in the operative part.
Right. Okay, I did say we said in our directions that this wasn't a chance for the other side to have another go, but I do want to hear what you say about that. Do you accept that what Mr. Jeremy says is right? Because your brief argues that we can't use it at all.
I think our argument is this: whether we were given notice that the prosecution say that the Zakat office was raided or not is really beside the point. That the indictment or the document containing the charges sets out the crimes, the counts for which Mr. Abd Al Rahman is charged. He's not charged with anything to do with looting of that specific location. I mean, I'm sure that there's agreement that Your Honours can't convict him of that. That is clear. But I think our argument is.
Well, you say we
very
should give it no
simply
consideration. Sorry, to interrupt Mr. Edwards and particularly the interpreters, but you say we should give it no consideration. Mr. Jeremy says we should.
Yes.
Because it's there, and it's, I suppose, in the same way as the villages which are attacked are not part of the charges either. It's part of a pattern of conduct.
Yes, I mean, I think the thing that we would say distinguishes the looting of the Zakat office is that the Zakat office is actually in the town, which is at the heart of it. You know, that's where the crimes that are being charged have been committed. So I think our argument is simply, if they were going to say, if they were saying that the criminality for which he is charged, the criminality for which convictions should be entered in Mukjar, in Bindisi, that should be comprehensive. And where the prosecution have taken a positive decision to not be comprehensive about the crimes that are to be charged in Bindisi, then it's unfair, we say, for them to try and use the Zakat looting allegation, even if it's not an allegation that can result in a charge, but that they ought to put it this way: they ought to put their money where their mouth is. They should have explained why they're charging Zakat, given that everything else that was occurring in Bindisi that they're charging were matters that Mr. Abd Al Rahman could face a conviction on. We understood them to be pretty comprehensive in terms of what was going on in Bindisi, and the Zakat looting would fall outside of that.
Yeah, all right.
I think that's what distinguishes the context argument otherwise.
Yes, all right. Okay, the next question, which is question 17, paragraph, again for the prosecution, paragraph 330, and Annex 12, you refer to the alleged rape of P1P074 in a forest south of Bindisi. Why do you say this incident falls, given the scope of counts 8 and 9, why do you say this incident falls within the temporal and geographical scope?
Thank you, Madam President. As regards the geographical scope, we describe in paragraph 330 of our brief that victim P1074 was present in Bindisi on both days of the attack, the 15th and the 16th. Then she fled the attack to a farming area between Bindisi and a forest. And she was chased there from GOS militia forces inside Bindisi to that location. So we submit that does fall within the meaning of the surrounding areas because she was targeted as she
Wasn't it defined when a query was raised as fields?
It was defined as roads and fields, and our feeling is that a forest with more or less trees would fall within the definition of surrounding areas.
Right. What about the temporal?
So, in relation to the temporal scope, we recognise that the confirmation decision does date the attackers between the 15th and 16th of August 2003. However, again, we've consistently pled that that attack was dated on or about the 15th and the 16th of August 2003. So in our submission, an event that takes place a few hours after the 16th would be included within the temporal scope, and again, we would rely on the Entiganda appeals judgment, paragraph 326 that I referred to before.
Yes, thank you. Then question 18. It's covered, is it? Right. 19. You think it's covered? Okay. 20, no, well, has it been covered? Yeah, I think it has, yeah. I think that has...
Sorry, Your Honor, go ahead.
I'm sorry, we're just checking that. I think that was covered, wasn't it? No, actually not the central roads, the PDF. Yeah. No, do you want to go ahead then?
Yes, so I think we have bits and pieces of this question that haven't been answered. Yeah. It's been referred to, though, but question 21 for the prosecution. With respect to the CRF and the responsibility or the linkages, according to the prosecution, with the accused.
Yes, thank you, Your Honor. Paragraph 414, Your Honor, is the acts by the CRF listed at that paragraph. These are acts illustrated that the CRF acted in concert in terms of location, time frame, and the crimes are of a similar nature and purpose. This has not been charged per se, though, so it's indicative of cooperation between the forces.
So then is no?
Not those particular incidents, Your Honor.
Yes. 22, I think, has been answered. I've written down, it was answered this morning, I think, by the defence. Yeah. Are you happy with that? Yeah. 24. Yes, the asylum record. Right, now let's have your PowerPoint, Mr. Edwards.
Yes, we got there. Can I ask the court officer please to bring up the PowerPoint? While that's starting off, we say, Your Honours, that a claim for international protection from persecution is a serious formal process, whether it be a claim to the UNHCR or to the state's own domestic authorities. We've produced this so that it can be broadcast it's appropriately redacted, so it can be. Is it on Evidence Channel 1? Yes. Yeah. Let's stay here for now. It's a serious process, whether it's a claim to the UNHCR or to the appropriate authority of a state, and claimants are expected to tell the truth.
I believe my friend has been saying witness codes and the country.
Yes, that should be.
Thank you. They're not displayed.
Yeah. So, there it is. They're expected to tell the truth. They're expected to be cooperative. That is made entirely clear to claimants for asylum, and that failure to tell the truth can carry serious consequences, not just in terms of the outcome of their asylum claim, but also they're open to penal sanctions. What we say is that this can be taken off the screen now. Lying in an asylum application, it is a deliberate undertaking, isn't it, by a claimant? It requires, it's a deliberate action. It's not something that is done by accident. It is high stakes, because the claimant knows what the consequences are if he or she is discovered. One doesn't do it on the spur of the moment. It's calculated. Your Honours may think that certainly the further into the claim for asylum a claimant gets, the lie will have been repeated. You may think that the lie would require a degree of practice, rehearsal, before the telling. And then in some applications, when they sign to say that the application represents the truth, that in itself is an untruth, isn't it? It is not only dishonest in and of itself. We would submit that whilst we will always have sympathy for the position of an asylum seeker who genuinely has a well-founded fear of persecution, but lying is nevertheless a cynical endeavour. It represents a gaming of the system very often, taking advantage of the rules and taking advantage of the generosity of institutions and countries willing to welcome and provide protection for people who have a well-founded fear of persecution. In addition, those who lie and are caught out contribute to asylum processing applications in which a culture of cynicism develops, a culture of disbelief, and many countries will be aware that this is a real danger, that those who are tasked with assessing claims for applications and processing claims for applications, and even the judges who go on to deal with appeals against first instance decisions, who encounter time after time after time untruthful claimants, this creates a culture of disbelief which disfavors then all the genuine claimants for asylum. It creates a weariness, a hardening amongst caseworkers and judges. And it's depressingly familiar to anyone who works or has worked in the system before. So your honest question really, I think, is this, isn't it? How are we to take this into account? Does it raise serious doubts as to the overall credibility of a witness's in-court testimony? We say yes, it does have, it should have a real impact on your assessment of credibility, because once again, a lie when one claims asylum it's not a spur of the moment thing. It's deliberate, and it's very often repeated. It's and you want
I
to
think we've
my
got the point,
yeah.
Mr. Edwards.
Can I say this? We have had in this case, when cross-examined on an untruthful asylum application, the witnesses will say, well, yes, I did lie, but I'm telling the truth now. It would be interesting to undertake a thought experiment and query, well, what would the witness's account be if he was being cross-examined on an inconsistency between an ICC witness statement and his application, right? If the stakes were that he or she was at risk of having his refugee status removed from him because of lies, you could well imagine that the response there would be, oh, no, I told the truth on my asylum claim. The ICC account was a lie because, well, whatever. In the immediate circumstances, which account is a witness more likely to point to and say, this is the true version? So really what we say is that in a formal scenario, evidence that a person has lied, evidence that a person is prepared to and is willing to lie for his or her own benefit in that circumstance is something to take into account. And in this court, in Ruto and Sang, in fact, where information from a very important one of the key prosecution witnesses in Ruto and Sang, it became clear that he had given a completely different account in his asylum claim in the Netherlands, I think it was, and in the event, it led to the prosecution dropping this star witness in their case against the defendants, and that had an enormous impact on the prosecution's success in the Ruto case at all. So, yes, in short, it is important and it ought to be taken into account.
Yes, thank you. As far as question 25 goes, that's been dealt with. Yes, 26.
Yeah.
Judge Alexis Windsor.
That's me again, Your Honour,
yeah.
and I can deal with that very, very briefly. I'd ask you to take into account what is contained at item 140 on our list of materials, P720 in a witness statement, paragraph 69. At item 140 says, even though the majority of the PPF were for, they would not engage with Ali Kusheb's forces, and when they arrived and caused chaos. paragraphs 93 to 94 in the statement refers to someone, the second in charge of the PPF in that area was a 4. Item 112 on our list of materials is a document from P883, paragraph 260. In fact, I think this ERN, DAR OTP 0000065, it's one of those documents that's a summary, an amalgam of key parts of his evidence to assist the court. But anyway, paragraph 260, he says the PPF never participated in the attacks by Janjaweed. Most of the PPF officers in Garcilla belong to the Fur tribe. He goes on to say that they were arrested and detained for a time. But in terms of what your question is, we say that that is evidence that most Fur, the majority of police and PPF in Mukjar were Fur. Now, I accept that this one was Garcilla, but it makes the point. Specifically relating to Mukjar, item 116 on our list, witness 986. That's one of his statements, paragraph 86. Most policemen were Fur. He says their guns were confiscated. So we say that there's enough evidence to support that claim.
I would have thought, I have a feeling that you've answered question 27, haven't you, about the Salamat forming the bulk?
Yes.
Yeah, that's what I rather thought.
I think I dealt with that either this morning or
Yeah, that's right. Yeah. Then question 28. I think you've also dealt with very clearly both in your final speech. Namely, you say you are not putting forward a defensive alibi effectively for Mukjar because you haven't been able to get the documents.
Yes, and we have said so as well in the filing of last week.
Yeah, that's right. Yeah. Okay. Question 29, John Jalapini.
Merci, Madame la Présidente. Par rapport à cette question-là, c'est une question qui s'adresse à la défense. J'ai cru comprendre que vous avez beaucoup, vous vous êtes beaucoup étendu sur la fabrication des preuves. Mais j'ai une petite préoccupation par rapport au paragraphe 201 et 202 de vos conclusions finales. Là, vous avez fait allusion à 2 témoins, le D022 et le D547, sauf erreur de ma part, oui. Non, le D022 et le P0547. Est-ce que vous pouvez vous étendre un peu plus sur comment ces témoins ont pu fabriquer leurs preuves et quel impact ce que vous prétendez peut avoir sur notre manière de comprendre cette question.
Thank you, Honor.
Merci.
I'll answer in English if I may. First of all, can I make it clear, we're not suggesting that P547 was fabricating his evidence. The investigator, clearly a very switched on individual, starts putting to the witness, well, we have information that we have information to the contrary, and it is put to the witness that there are parts of his story that don't add up. And then the witness very, very quickly crumbles. He informs the investigator that his entire story was untrue. He says that he had been engaged by someone who he presumes was involved with Jem in Khartoum, to come to Asmara to meet with ICC investigators and to give a completely false account that he had been promised by his contact, who he assumes was from GEM in Khartoum, that he would be given 15 million Sudanese pounds to come and mislead the ICC, and a house in Khartoum. He said, well, I don't know why I've been told to fabricate this story, but there was a lot of money to be made. There was material benefit to me and my family if I pull this off. So yes, he confessed that it was all completely untrue. But and P547 corroborates this, and he corroborates it. Well, it's in his statement. His statement, of course, is not in evidence, but in the transcript of his testimony, it's T52 from the 17th of June of 2022, one of the very first witnesses that we heard. And I direct your attention, Your Honours, from page 33 to about page 40. And it's in the course of Mr. Lauchi's cross-examination of the witness that he talks about this incident in Asmara that he's aware of. So this is a clear, corroborated account of actors in Sudan, actors who are, for want of a better word, the enemy of the Sudanese government, taking very concrete steps with a lot of money behind it, or certainly promises of money, in order to mislead the ICC. This isn't just, the reason why it's so relevant is it's not just to mislead, I don't know, investigators from the international community broadly, nebulously. It's to investigate specifically investigators of the Office of the Prosecution of this precise institution and in respect of this case. When I say this case, it's you know, the case relating to Darfur. The target, it's not clear who the target was. We're not suggesting the target was necessarily Mr. Abd Al Rahman himself, but certainly the Sudanese accused. And that's rather important, we would suggest. Although Your Honours don't refer to it in the question, because you're referring to a very specific paragraph, can I also remind you of the evidence of our witness D26 Colonel Markey, who testified on the 21st of March of this year, T147, and he explained himself about, you know, during his time with the AU mission in Darfur, that there were occasions when he got the distinct impression, and in fact was able to prove it on occasion, that he and his colleagues, being persons from the international community, from the African Union, were being spun by variously agents of the insurgency and the government of Sudan itself, presenting with scenarios that he said that he was presented with scenarios on numerous occasions that he felt had been constructed, that didn't represent the truth. And really, Colonel Markey's evidence is not directly relevant, but it's not entirely irrelevant either. We say that it's something that, where there's evidence of sophisticated or less sophisticated attempts to fabricate evidence for the consumption of the ICC, it's something that you can properly weigh in the balance. It is something that, I won't say throw in the mix, but it's something that you can be aware of, and to ensure that you keep it at the forefront of your mind when considering the evidence in its totality. can I just finish by saying this? This danger, this reality, would perhaps be less acute had we been in a case where both the prosecution and the defense had been able to get into Darfur and to undertake a deep dive, to actually carry out investigations ourselves on the ground. We would be in a much, much stronger position, both of us, to be able to carry out our own checks on what is contained in witness statements. We just haven't been able to do that. It speaks for itself that the ability to get onto the ground and to see for oneself the fields, the hills, the villages, if a certain thing could be seen from a certain vantage point. If you're in this village, you would be able to see this field or this mountain. Sorry, I see that my friend.
Yeah, I'm sorry. I'm really reluctant to stand up because this is a closing, even though we're in argument. I think this is going way beyond the answer and is turning into further submissions that if it keeps going, I'm going to have to ask you to respond.
No, I think that's probably right, Mr. Edwards. I mean, it was a fairly restricted question.
I accept that. I was simply making the point that when one can get beyond the ground, you can check things out. Here, very different.
All right, yeah. Well, I think you've made the point. Yeah, thank you very much. Thank you.
Oui, merci Madame la Présidente. J'ai eu réponse à mes préoccupations. Merci.
And the final question has in fact been answered by the. I added two yesterday that I want to come back to, but and that relates to both what the common legal representative of the victim said in the final brief at the last paragraph, and indeed was repeated in the final address yesterday. Namely that they ask the chambers to make explicit findings in the judgment reflecting the extent of the harm and official recognition of the court. And the defence have responded already in writing. Does the prosecution have any views on this?
No, Your Honor, it's just to say that obviously what's evidence is what has been presented to you. That's all that you can take into account.
Yeah. All right, then I added two further questions yesterday. The first was a very simple one, and simply I couldn't find it. Do we have any evidence? It's accepted that Mr. Al Rahman there was an assassination attempt on him, I think it was 2013. Do we have any evidence of the injuries that he suffered? Was it only just newspaper reports, or did any of the witnesses say who went to see him or say what injuries he'd suffered?
Thank you, Your Honors. It is mainly two newspaper reports, one from the Sudan Tribune, one from Radio Dabanga, which we took a look last night, and these, in the English translations, one says he may have been hit in the leg, but what's more consistent is that he was hit in what's described as the shoulders or the arms in the translation, but having, and we could bring it up if necessary, but having checked the translation carefully, it appears that another reading of that could be hands or hand. And I'm not an expert. We looked at it. We could bring them up and have the interpreters look at it, or that could be done.
Well,
but it appears to be hands or arms, and
well, I mean, the reason I brought it up was I happened to be reading the evidence of Miss Marsh, the handwriting expert, and Miss Whitford cross-examined about whether handwriting could be affected by injuries. And I assumed that she was referring to this, and I just wondered if there'd been any evidence. And you say it's those two reports, and you say that something can be translated as hands.
That's right, and it's also P119, Your Honor, in his statement. That's DAR OTP 0124-0196, paragraph 124, he says, P119, that the accused was hit in his hand.
Right.
That's what's in the statement.
Thank you.
And also, now in the testimony, it comes out as arm. So there is some nuance to the language, and somebody is talking to me, so yeah. Sorry, Your Honor, that was helpful. It's actually the right hand, and I missed that, or right arm.
Right.
That was discussed by
Yeah.
P119.
Thank you very much. Right, Mr. And then the last question is really for the defence, and it's this, and it relates to effectively the paragraphs starting at 258 of your final brief, and the point being made by Mr. Nichols when he was speaking that you haven't pleaded duress and you agree that. You haven't also mentioned anywhere that I found anything to do with Article 33, superior orders. So what, therefore, is the relevance of the death penalty being available in Sudan for the disobeying of orders, you would argue, whether legal or illegal?
Merci Madame la Présidente. Je vais vous répondre en français car votre question est pour moi l'occasion de recycler les arguments que j'avais préparés en réponse aux représentants légaux des victimes en liaison avec la ligne 3 et que je n'ai pas pu dire ce matin. Et effectivement, les deux aspects, contrainte et ordre, vont ensemble et vous allez comprendre très vite pourquoi. Alors, de façon très claire, nous ne plaidons ni la contrainte, ni l'excuse d'ordre hiérarchique. Néanmoins, ces deux éléments, d'ailleurs qui sont les deux, pour nous les deux faces de la même médaille, contrainte parce que ordre, sont pertinents pour ce qui concerne l'établissement de l'erreur de droit en vertu de l'article 32, paragraphe 2 du statut, l'erreur de droit, oui, et l'absence de connaissance du caractère criminel des faits, article 30, paragraphe 3. Les témoins P20 et P954 ont rapporté la preuve de l'obligation d'obéir aux ordres donnés sous peine d'exécution sommaire sur le champ de bataille. Ce sont les pièces 51 pour le témoin P120 et la pièce 115 pour le témoin P954. Cette obligation ne distingue pas en fonction de la légalité de l'ordre, dont la première définition de l'ordre illégal a été introduite dans la loi sur les forces armées de 2007 à l'article 3. C'est la pièce 123. Nous soumettons donc qu'il est raisonnable de dire que pour ceux qui en avaient connaissance de ce risque d'être exécutés sommairement sur le champ de bataille en cas de désobéissance aux ordres, cette information avait pour effet d'amener à croire que, ou du moins de conforter dans l'idée, que la réalisation des actes visés dans les charges était obligatoire une fois que l'ordre en avait été donné par une personne avec autorité. Le témoin P883 nous a éclairé sur le fait que cette obligation d'obéir aux ordres faisait partie du b.a.-ba de n'importe quel soldat qui entrait dans l'armée au moment où il faisait ses classes. Un soldat obéit aux ordres reçus sans discuter. Monsieur Abd Al Rahman, qui est rentré dans l'armée en 1964, a donc dû être informé de cette obligation. Cela ne fait aucun doute. La thèse du bureau du procureur est que la totalité des crimes qui sont visés dans les charges font partie d'une contre-insurrection qui aurait été décidée au plus haut niveau de l'État soudanais, en particulier par le président al-Bashir lui-même, et nous sommes d'accord avec cette théorie. Et quoi qu'on pense du président al-Bashir, il ne fait aucun doute que sa position d'autorité pour ordonner ce qui a été fait ne faisait pas de doute dans l'esprit des Soudanais. Il est donc raisonnable de conclure que la connaissance de cette obligation d'obéir aux ordres sans discuter sous peine d'exécution lorsque les ordres émanaient d'une personne avec autorité a dû et pu jouer un rôle certain sur, premièrement, l'erreur de croire que la commission des actes visés dans les charges était obligatoire, et deuxièmement, l'absence de connaissance du fait qu'ils étaient interdits.
That was a wonderful dissertation, Mr. Fauci, on
Merci.
but I really want an answer to the question. Are you saying that although you haven't pleaded it anywhere in your brief or indeed in your final address, you are actually saying there is evidence which you want us to consider which shows duress? That really does, require a yes or no answer.
Il faudrait peut-être pour cela définir la duresse, la contrainte, mais nous estimons que cette menace d'être exécuté est une forme de contrainte.
It's defined in Article 31.
Et dans ce cas-là, la réponse est oui.
Right. What about Article 33, superior orders? Are you also saying there is evidence which we should consider in respect of that defense?
Cette preuve de l'ordre, comme la preuve de la duresse, et je viens de la mentionner, P120, P954, est pertinente pour votre délibération sur la ligne 3 de la défense. C'est tout ce que nous disons. C'est-à-dire l'établissement ou non de la connaissance du caractère criminel et l'erreur de droit.
Right. Well, I suppose, as you haven't mentioned it before, Mr. Nichols, I'm not going to order you to reply now, but do you want leave to respond to that?
Well, yes, but if I can respond right now, he cannot plead duress after the closings are done, except for the judge's questions. When I don't have the cite, expressly in the opening, they said they were not pleading duress. Yeah. Expressly in the opening, they said we are not pleading duress, not pleading superior orders. Superior orders would not apply anyway to clearly unlawful criminal acts. But all along, we have been proceeding, and it's been discussed at different points it's come up, that there is no duress defense. So it cannot, the answer to that, with all respect, I don't think the question even needs to be asked if he's asking duress to be considered, because throughout this trial, from the opening, he has said, we are not pleading duress. So it cannot be raised at this point when we have zero ability to cross-examine on this or to introduce additional evidence on it, and it was not discussed with an expert, which is the kind of thing that we would have dealt with in this manner.
Madame la Présidente, mon confrère a parfaitement raison. Et désolé si ma réponse à votre question n'a pas été claire ou s'il y a un malentendu. Tout ce que je viens de dire, il n'y a strictement rien de neuf. Cela faisait partie de nos soumissions lors de l'audience de confirmation des charges. Tout a été dit à ce moment-là. Et il n'y a aucune espèce d'évolution sur notre ligne 3 depuis cette époque. Donc encore une fois, l'existence de l'ordre et la menace d'être exécuté pour ne pas les exécuter sont pour nous uniquement des indices pertinents pour votre délibération sur la ligne 3, c'est-à-dire l'erreur de droit et l'absence de connaissance du caractère criminel. Je ne pense pas pouvoir être plus clair. Et non, nous ne plaidons pas, à aucun instant précis du scénario des charges, ni la contrainte, ni l'ordre donné.
No, well, that's the problem, Mr. Lachy, and that's why I asked the simple question I asked is what's the relevance of the death penalty and all the rest of it.
C'est une simple question de connaissance. Quelles étaient les informations en possession d'une personne telle que M. Abd Al Rahman qui avait fait 25 ans d'armée? Ce qu'il sait, c'est que s'il n'abouit pas aux ordres, ça risque de très très mal finir et très très vite pour lui.
All right. yeah, we'll see where we get to. But I think that you accept it was never raised, and that the prosecution may well have conducted its case completely differently had it been raised properly.
Can I make an analogy? It would be like in a national case, the defence pleading something that sometimes is called a sub-duress mitigation. It wouldn't amount to duress that would permit a jury to acquit the defendant of something that he's charged with, but the factual basis surrounding the factual information that there was a degree of duress is still nevertheless relevant for the consideration of the court, in the case of this analogy, for sentence, perhaps.
All right.
So it could be raised, but not, but on the understanding it doesn't amount to a full defence.
Well, yes, I mean, as you know, in order to establish duress, on which the onus is on you, there are certain things you have to show which have never been dealt with at all in evidence. But all right. Everybody else has thanked everybody, so I suppose the chamber had better, the trial chamber had better do the same. This is the last hearing that we will have in this case, and it is extremely regrettable in so many senses, most of all for the people who are suffering at the moment, that this trial was not able to conclude at an earlier stage because of the appalling events going on at the moment in Sudan. But it has gone on for some time, if sporadically. And I would, first of all, like everybody has already done, like to thank the court staff who have been throughout this trial, as I say, interspersed by breaks of supreme assistance, I think, to all parties, participants, and everyone who has dealt with this trial. Second, the interpreters. Without interpreters, you couldn't have trials. And from time to time, there have been a few hiccups, if you like, but by and large, the interpretation has been superb. And I think I ought to specifically mention the four interpreters. I don't imagine, or I'm not sure, they may be here today, who had the unenviable task of having to be trained within a matter of months to become court interpreters. Without their assistance, a number of the witnesses wouldn't have been able to give their accounts to the court. And so I do offer a special thanks on behalf of the court to them. Those who operate LiveNote, type the transcripts, again, they don't often get a mention. They should do. Things happen sometimes slowly, sometimes at speed, but they do a pretty good job of reproducing what was said in court. Fourth, I've said this before at various intervals during the trial. We, the judges, would like to thank all counsel and their teams, whom they've mentioned in their thanks, for what has been, I think certainly by the standards of this court and other international tribunals, a remarkable degree of cooperation. There have been blips, as there always are, but that cooperation, I emphasize this, is vital for the efficiency and the expedition of what are very lengthy and complicated trials. Mr. Khan, the day before yesterday, complimented the judges for their efficiency, but we want to make it absolutely clear that our efficiency is dependent on cooperation by the parties. And efficiency is in the interests of not only the accused, who's the person, after all, on trial, because the trial goes faster than it would otherwise go. The victims, who, as Ms. von Wistinghausen pointed out, have been waiting many years now for some kind of recognition of what happened to them, and also to the public in general. As I already said, the evidence would have concluded, and indeed I think the judgment may well would have been issued had not events taken place in Sudan from April of last year. And it is unfortunate, as I say, that what is going on there from the accounts appears to be very much a repetition of what happened in 2003 and 4. And finally, we would like publicly, and unusually I think, to express our thanks to the legal staff working for the judges, because they are the intermediaries between the judges, the administration, and other interested parties in the case. And that communication between them and, as I say, the other parties is absolutely vital when it comes to the smooth progress of a case. And we would like to say, and I'm sure Council would agree, that it is their contribution which has contributed in no small measure to what, as I say, Mr. Khan described as the efficiency of the trial. So, having delivered all those thanks, it simply remains for us to declare the hearing at an end. Parties will be notified in due course, obviously, of when judgment will be delivered in this case, and it's appropriate that we should finish just before Christmas. So we wish everybody a happy Christmas and a prosperous New Year. So thank you all very much.
All rise. We will.